Good morning, everybody. My name is Romy Jurado. I'm an attorney. I've been an attorney for over 14 years now. One of my areas of practice is commercial leasing, and I do see it from both the transactional side, where you're negotiating the lease, and the litigation side, where already issues happened. I help a lot of realtors and their clients all over the state of Florida. And as you will see, it's not just commercial leasing that gets involved in this type of deals. You might see other situations that happen, such as a landlord dying, or there being violations, zoning issues, and different things that may arise. So commercial leases 101, very basic class. We're going to talk about a little bit of an introduction, some factors to consider in commercial leasing strategies, some of the types of commercial leases that you might see, and key provisions in commercial leases, legal and regulatory compliance in commercial leasing, common challenges and solutions with commercial leasing, and best practices for a successful commercial leasing transaction. So first, what is a commercial lease? So commercial leasing in Florida refers to the renting of real estate properties for non-residential purposes, such as offices, retail stores, and industrial operations. It is governed by a lease agreement that outlines the terms and conditions for the rental. There are various types of commercial leases in Florida, including gross, net, triple net, percentage, and modified gross leases, each with a different expense allocations between the landlord and tenant, and landlord and tenants must comply with certain regulatory requirements related to commercial leasing. When it comes to commercial leasing, unlike residential leasing, we don't really have default protective statutes. While we do have statutes that may regulate the transaction, the way the courts look at leases is if you agree to it, you're bound to it. So it is extremely important to read the whole lease, even if it's 50, 60, 100 pages, and understand what either the landlord or the tenant is agreeing to. Here also, it's important to understand what is not a commercial lease and what it is. For example, about 4 years ago, 5, people started renting houses, like single family homes or apartments, but they were not renting it for themselves. They were renting it to put it out in Airbnb. So that, in effect, is a commercial lease because you're not renting it for yourself, you're renting it to put in business. So that form that you guys have for residential leases should not have been the form that is used for a commercial lease, and that actually led to a lot of litigation. Another thing that I like to point out is that it doesn't matter what title the lease has, because it could be called a gross lease or a triple net lease, and in reality, it might be something different. So let me just give you a little bit of a description of what each, of those leases that I mentioned are. So let's see. So usually it might be that a gross lease, it's also known as a full service lease. So a gross lease is when the tenant pays a single monthly rent amount and the landlord is responsible for all property expenses, including utilities, property taxes, and maintenance costs. Usually you will see this in office. That could be the case. This type of lease provides tenants with predictable monthly rent payments, while landlords have more control over the property and its expenses. Then we also have a net lease. So in a net lease, the tenant pays a lower base rent amount, but is responsible for paying certain property expenses, such as property taxes, insurance, and maintenance costs. Also, there are 3 subtypes of net leases. You can have a single net lease, a double net lease, and a triple net lease. In a single net lease, the tenant pays for property taxes, while the landlord pays for other expenses. In a double net lease, the tenant pays for property taxes and property insurance, while the landlord pays for the maintenance costs. And in a triple net lease, this is where the tenant is responsible for everything. They pay for the taxes, they pay for the insurance, and they pay for the property maintenance. So you may have a lease and may say it's a gross lease, and you assume that means the landlord is covering all expenses. But as you read through it, it might tell you that the tenant has to pay for this to maintain this. The tenant has to pay for this property tax. The tenant has to have this insurance. And then in reality, while it's called a gross lease, it's really a net lease. That is why it's so important to really read the lease, not be guided by just the title. Then we also have, even though less common now, percentage leases. So in a percentage lease, this is usually used in retail properties where the tenant pays a base rent amount plus a percentage of their sales revenue. This type of lease is beneficial for both the landlord and tenant, as the landlord can receive a percentage of the tenant's sales revenue, while the tenant has the potential to pay less rent, right? if their sales are lower. So I used to see this a lot in malls, not as much as I do now. Now I see a lot of malls changing for percentage lease to regular gross lease or net lease most of the time. And then we also have something called modified gross lease. A modified gross lease is a hybrid between a gross lease and a net lease. In this type of lease, the landlord and tenant share responsibility for certain property expenses, such as utilities and maintenance costs. The specifics of a modified gross lease can vary as both parties negotiate and agree on which expenses will be shared and how they will be divided. And again, that would be all part of the lease. So we talked a little bit about the different types of leases. We'll go more in detail in a little later. Now let's talk about the Florida statutes that regulate the real estate leasing transaction. As I was telling you, residential leases have default statutes and commercial leases do too, but the residential really protects certain things. For example, in a residential lease, if you're trying to terminate the lease, you need to give them 60-day notice, right? In a commercial lease, you don't need to do that necessarily. In a residential lease, if the lease is expiring and you want to increase the rent, then you have to give them 30 or 60-day notice. In a commercial lease, you don't have to give them any notice. You could say your lease expired, you want to continue renting the place, I'm going to increase your rent by 20%. And if you don't want to accept that, then you're simply not going to be able to occupy the property. So some of the important terms as it comes to leases. I don't see any questions yet, but if you have any questions, please put them in the chat. Okay, not yet. The description of the premises. This might seem so basic. In a residential lease, you usually have an address, you have a folio number, it's either an apartment or it's a house. In a commercial lease, that might not necessarily be the case. In a commercial lease, you may not have that because maybe it's a new construction that you're renting and they has the same folio, right? The same tax number, but the landlord decided to divide it by bays, bay 1, bay 2, bay 3. But that's nowhere in the legal description because in the legal description, you only have one folio with one address. So when you enter into the lease, you may have put bay 1 and you think it's the one right on, let's say US 1. But in reality, when you get possession of the property, they put you all the way in the back. And there's no way for you to say where it was unless you did a map. So all commercial leases, regardless of even if it has an address, you should have a specific drawings of what is it that you're renting, right? So where is the location that you're renting at? And if you're renting and you have access to the outdoor space, then that map should outline that you have access to the outdoor space so that no other tenant can use it. So it's very important to describe the premises, okay? Also, in describing the premises, we want to talk about square footage. Even in residential, but in commercial, more likely than not, you may be renting 800 square feet, right? So if you measure the place, it's 800 square feet. But the landlord will put in the lease that the place is deemed to be 1,000 square feet. So you're paying rent based on 1,000 square feet, and the lease will say that it is deemed to be that, and there's really nothing you can do about it because you agreed to it. So that is also important when describing the premises, understanding what is it that you're renting and what is it that you're paying for. Now, also the term of the lease. The term of the lease is very important as well because usually I recommend my clients to have shorter terms for when they're doing a lease. Why? Because we don't know how long the business is going to do well there or if it's going to do well at all. What if the client, let's say they started a store and they're selling antique goods and they have a lease for 5 years? But after the first year, they realized that, nobody's buying our antique goods here. We're better off selling just online. Why are we going to pay so much rent? Those things can happen. So for that, I recommend the clients to basically negotiate a shorter lease term, but with options to renew. So maybe that client should have negotiated 2 years, 3 years of rent, or even 2, but you have 2 or 3 more options to renew for additional 2 or 3 terms. And also you want to negotiate that those options to renew have a cap. Because what good is it that you have an option to renew, but now the landlord can basically increase the rent by 20 or 25%. That actually happened to one of our clients and to many of our clients actually. But one that I remember, it actually ended up in litigation. It was the lease was expiring. It was a restaurant. And as you can imagine, you cannot just pick up and leave, right? In a restaurant. So the client had an option to renew. They exercised their option to renew, but then the landlord came back and said, well, now your rent is increased by 20%. And the client came to me and said, Romy, how can I increase my prices by 20% and still remain competitive, I'm basically not able to operate there. And I said to him, well, we can try to fight, but your lease says what it is. So that's a very difficult situation because restaurants cannot just pick up and leave. If there was a consulting business, they can just go somewhere else, but not restaurants. So it is important to negotiate, if you're the tenant, a shorter term with options to renew and a cap on those options to renew. So when it comes renewal time, you'll be able to renew without an issue. Also, you want to understand the rent payment terms. What is rent and what is not considered rent? In a commercial lease, everything can be considered rent. The additional rent that you pay for the maintenance, right? That's rent besides your monthly rent. The common area expenses is what I'm referring to. That's considered rent. Even if those common area expenses include fees that your landlord's paying to promote the location in other countries, salaries that he's paying to his family members or her family members, if that's all considered rent and you don't pay it, they can evict you fairly quickly. In a commercial tenancy, for non-payment of rent, basically what the landlord does is give you a 3-day notice that specifies what is it that you didn't pay. Then if you don't pay that, they can start an eviction process for non-payment of rent. You're only going to have 5 days to answer that eviction process. And the answer can be, I pay the rent, or I pay the rent. You cannot fight it unless you actually deposit that money into the court registry. So that is why it's so important to understand what is considered rent, because that's the easiest way a landlord can use to evict you from the property. Because if something is considered rent and you didn't pay it, then your only option is to deposit money into the court registry and then argue why is it or it's not rent. But if you don't deposit that money into the court registry, then you're not going to be able to defend against an eviction for possession because of non-payment of rent. Security deposit. This is important to understand what a security deposit is, and understand that it's going to increase as your rent increases most of the time. For example, I had another client. He was there in the location for 10 years. Okay. And he loved it there. He had a good relationship with the landlord. The building was sold. So whoever bought it went to an attorney and said, look, I really want to get this tenant out. I want to turn down the building and sell it and build a new building. And so what the job of the attorney at that time was, how do I get this tenant out? He keeps on paying rent. He's not violating the lease. How do I get this person out or company out? So the way that they found to kick this tenant out is that they realized that while they made the security deposit 10 years ago, they never increased the security deposit as the rent increased. So the rent increased every year. The security deposit should have been increased also every year, meaning the tenant should have paid the additional amount of rent and increase the security deposit, because that lease said that. It said as years go by, you need to keep on increasing the security deposit as the rent increases. Well, the landlord had never sent a notice to the tenant. The tenant didn't even know about it. And the lease also said that it doesn't matter if the landlord doesn't give you notice, that it's your duty to do it, and the landlord doesn't waive the right to evict you because of it. And that's essentially what happened. They sent a 3-day notice to my client that he had to pay, I don't know, like $30,000. And of course, he didn't have it. And like I told you, the only defense to non-payment of rent is I pay the rent. So he had to pull that money, put it into the court registry. And then what he wanted is, Romy, try to fight this and last as long as you can so that it gives me some time to find another restaurant and to move, because I just don't want to close my doors and lose all my clientele. We were able to fight it for like 9 months, I think. We got a little creative. But at the end of the day, it was considered rent. So he needed to eventually pay it. But at least we kind of help him that way. So it's very important to understand what a security deposit is and to understand that as rent increases, that security deposit is also going to increase. Okay, let me see. I have some questions here. Good morning. Maybe this was already mentioned. My apologies. How much deposit do tenants normally give at the start of the lease? With residential, it's normally 3 months. How much is it in commercial? That's a great question, and it totally depends. So for example, I represent all sorts of tenants, right? When it comes to commercial leasing. Some of my tenants that I have most of the problems with are the foreign tenants, because we do business immigration. So basically we help foreigners come to the United States, obtain a visa, obtain residency. And in order to do that, they need a business. And in order to have the business, they need a location to rent. And of course, they do not have credit history and they do not have a social security, because we need to get all of this in order to get them all of that. So there, I usually negotiate with the landlords, sometimes even 5 months of rent, Sometimes we negotiate a standing letter of credit. Sometimes we get an additional person who does have all those things to sign and guarantee the lease. And then we can also negotiate that after a year of good payment, they can release the other guarantor, or that after a year of good payment, they return 2 months of the 5 months they got in at the beginning. That's usually what I face with my foreign clients who don't have socials, who don't have good credit score. With US people that have socials but don't have good credit, it's also the same thing. Because yes, the lease will be under the name of your company, but if your company has no assets, what really is guaranteeing the lease? It's you personally. So the landlords would ask, again, 4 months of rent, a standing letter of credit for maybe 1 year of rent, or for another guarantor that's not even part of the business, but that's going to give them some security. So again, that's all negotiable. For my regular tenants, the ones that do have good credit scores, the ones that, do have Social Security, do have a good company that has been set up, I would say 2 months, it's normal what they get. 2 months of deposit, or 1 month of deposit and 1 month of advance rent. Usually those are the people that have good credit, has, good history, have socials. The other ones, it just depends on the particular situation. Okay. And if they've had an eviction in the past, it gets even more complicated. It's not impossible, but it's always good to know all these things at the get-go. When you guys are out there trying to find these commercial leases, you have to ask your potential tenants, have you ever been evicted residentially or commercially? Have you ever filed for bankruptcy? Do you have a Social Security number? What can we tell the landlord about your stability here? What is your legal status? What are you doing this for a visa? Are you not? These are questions that we all have to ask in order to present it the best way possible to the landlord. Okay. Let me see. I see more questions. Can a broker get paid on the total rent or just base rent? That's actually a fabulous question that I'm going to answer more when we go into the letter of intent. But in my opinion, brokers are helping you find the location, right? So you go and found a fabulous tenant. So therefore, you should be able to get compensation on both the initial rent, the renewal of that rent, and if that tenant ends up buying the property, you can put that also in your letter of intent. And I have seen it in leases too, which is important. That's where it needs to go. Or if that tenant ends up renting more space, because that can happen too. You might bring a small tenant and they rent maybe 2,000 square feet. They love the place. They rent an additional space in the same shopping plaza, 4,000 square feet, and they eventually end up buying the building. If you put that in the lease that you will get compensated, you will get compensated. Because at the end of the day, you were the one that found this great tenant, and the landlord knows that. And so, you should be compensated. So that's totally fine. I put it on the lease. I put it sometimes on the LOI. I make sure to put it on the lease because it doesn't matter what goes on in the letter of intent, which we're going to talk about in a minute. If it's not in the lease, it's not going to happen. So that's where you want it. You want to mention it in the LOI, but you definitely want to see it in the lease. For everybody, my contact information is there in the chat if anybody needs it. Let me see. Is there a website that you recommend for a tenant screening for residential? I like to use Rent Spree. Does commercial have similar? So for a tenant, it goes more into the due diligence. I don't know that there is a particular website that you could go. I mean, you can check people's credit score. But what we do, if we're representing the landlord, is we check whether that tenant has had any lawsuits all over the United States, whether it's a state, county, or federal. Like if the client really wants to know who they're renting to, that's what we do. We also have access to a special system that tells us all of the companies and all of the potential licenses that person has had, and it gives us more of an idea. We have clients, landlord clients, that are really careful about who they bring in, so they have us do all of that. We don't do the credit check. That's something that you can do on your own, but we do all of that due diligence. It just depends on the landlord and how careful they want to be. So we have security deposit, maintenance and repair obligations. So for the maintenance and repair obligations, it's not set by statute. In residential tenancies, you're going to see that there's some default statutes of what the landlord has to do. It has to maintain a habitable place, all these beautiful things. Not in commercial tenants, okay? So you really need to read the lease and see whose responsibility is to maintain what. I had one situation with another client of mine. He had rented a restaurant in a commercial plaza, and the AC was on top on the roof, and the AC covered his restaurant and two other places. The AC was being faulty. It was not working. So the client came to me to tell me, Romy, what can I do? The landlord is refusing to fix the AC. So I look at the lease and I'm like, well, it says here that you're responsible to fix, to change, to replace the AC, and it even describes the AC, and that's on top of your roof. And he's like, yeah, but that AC covers 2 other units. Why do I have to fix it for the other 2 units as well? That's why that AC is so big and it's gonna be so costly. And I said, well, but that's what you negotiated. That's what your lease says. So regardless of what the lease says, if it's a commercial term, the judges are gonna enforce it. So you really have to be careful what you negotiate for. Whose responsibility is it to repair what? Before, for example, not as much now, we're getting a lot of lawsuits for discrimination, for violation of the ADA. So basically what happens is you have to prepare places, physical places, and they have to comply with the Americans with Disabilities Act, which requires, for the hallways to be a certain size, for the bathrooms to be a certain way, for the outlets to be in certain places. So what would happen is somebody would come and they would then, our client, the restaurant, will receive a lawsuit that says, a federal lawsuit, you're violating the ADA and therefore you need to fix all of this. And now the client had to fix all of that and defend themselves in court and get into some type of settlement to pay attorney's fees and costs. I used to see this a lot. And then the tenants will come to us and say, well, isn't this a responsibility of the landlord? If you look at the commercial lease, it's going to say that they're giving it to you as is, that they make no representations of anything, and that it's full the responsibility of the tenant. So in those cases, no, it's not the responsibility of the landlord. Could they have negotiated something? Absolutely. They could have negotiated something at the beginning, and we're going to talk about that in a minute. So maintenance and repair obligations, it's not default. It's what you guys agreed to. Subleasing and assignment, this is very important too. So when it comes to subleasing and assignment, you really have to think, what is your client, the tenant, going to be doing? Okay. So in the case of, let's see, beauty salons, for example, sometimes the owner of the business, right, is simply renting out those chairs to all of the barbers or to all the stylists. So in reality, the owner of the business, it's already subleasing. And if your lease doesn't allow for that, then you're technically already violating the lease. So this is something to think about, right? An assignment, most of the leases are going to require assignments to be approved by the landlord, okay? We had one situation where the landlord will not approve the assignment, So then I read at the clause of the lease that didn't say anything about changing tenants. Because see, the tenant is the company, right? So if you change the tenant, you're gonna need an assignment. And most of the times, if I'm representing a landlord, I say also a change in owners of the tenant requires an assignment, because I don't want them to just sell the company and now the landlord has somebody that they don't even know. But if the lease doesn't say that the change of ownership requires an assignment, then you might be able to get away with just selling the company, and that's technically not a violation of the lease. Now, the previous owners remain on the hook as personal guarantors, assuming they were doing that, but it is something that sometimes we have done because landlords just refuse to accept the assignment. Let's see. Insurance and liability. Most commercial leases, if not all, are going to require that the tenant has insurance, right? Why? Because they don't want to face potential issues, and they're going to require that insurance adds the landlord as an additional insured. So if anything bad happens, the landlord, they don't even have to go through you. They go directly through the insurance company in order to get the proceeds for whatever damage happened. That's common. I see it a lot. And I actually recommend to to landlords in residential leases to do the same. If you have a house that you're putting out for rent, you should require your tenant to get liability insurance, because they may have guests that may get injured and you don't want them to come after your insurance. You want them to come after your tenant's insurance, because they are the ones that invited those people to come in. And, it's just better. It's more protection for the landlord. Then we're also going to have a clause about dispute resolution. Now, those clauses, it depends. Most of the time, it's going to be in the court where the property's at, but you can choose that. For example, I represent landlords all over the state of Florida, and if I'm going to litigate, I don't want to go to St. Lucie, I don't want to go to West Palm Beach. I want to just do it here in Miami-Dade County, even though their properties are in Orlando and all over the place. That is something that you can choose through jurisdiction clause. You could say where and in what court you're going to have to litigate, and it doesn't matter that you live in Pensacola. If you agree to litigate in Miami-Dade County, you're going to have to come to Miami-Dade County to litigate it. All right, some factors to consider in commercial leasing. Of course, understanding the market and the market needs, what you can negotiate and where it's going to highly depend on what market is. Is it better for the tenants, or, our landlords just, they don't have any more space to rent out. So then the tenant really needs to accommodate, the location, the accessibility, all those things are things you're going to have to deal with and become familiar in your market as you start renting commercial spaces to tenants. We talked about building and repairs. It's very important to have a repair plan for the tenant so they understand exactly what's going on. Now, in commercial leases, what we usually do when it comes to repairs is we can do a 7-day notice to the landlord to fix the premises. And if they don't, then we can withhold rent. That's usually what we do in residential, and we try to do it in commercial too, if it's a repair that they needed to make. If it's not a repair that they needed to make, then you cannot hold them responsible for it. Tenant screening is super important to select the right tenant. Again, there are many websites out there. If the landlords really want to do the additional due diligence, that is a service that we provide, and we can help with that. They, of course, need to check their credit report, but sometimes they may not even have credit report. We talked about this before, but I want to go a little bit more into the different types of leases, even though please don't be tricked, because it might be called something, but in reality, it's something else. So we have the gross lease, usually known as a full service lease. You're going to see this in offices. You're going to see this, most of the time in offices. But even in offices, they're going to basically charge you some type of fee to do the cleaning or something, which I think sometimes is you can choose to or you can choose not to. Then this one provides more flexibility because the tenant knows exactly how much they're going to pay, and there are no surprises at the end. Then we also have the net leases. In a single net lease, usually the tenant is going to pay a lower rent amount, but they're going to be responsible for maybe the property taxes, right? In a double net, they might be responsible for the property taxes and also for, any type of maintenance expenses. And in a triple net, they might be responsible for property taxes, insurance, and all of the maintenance expenses. In a percentage rent lease, this is where they pay a little bit of less amount, but then the landlord receives a percentage of whatever the tenant is selling. I see this a lot in retail stores and in restaurants. I don't particularly think this might be a good or bad lease because it creates an extra layer. I'll give you an example of what I mean. For example, in a restaurant, right? When you're selling, you have to report all of your sales to the Florida Department of Revenue. That means that the Florida Department of Revenue is going to audit you whether you're collecting that, that sales tax that you need to connect and remit to the state. If you're doing a percentage lease, now you're going to answer to the Florida Department of Revenue, and you're going to answer also to the landlord, because your landlord is going to have to audit your numbers to see what you're selling so you can pay your percentage rent. From the landlord side, this also creates a headache because now you're basically auditing these people. And it's so easy nowadays to have 2, 3, or 4 points of sales. What do I mean? They might be selling with one register, and that's the one that you're checking, but then they have their phone or another little machine, and they're able to make sales through here too with another sales tax number, and you won't even know. So how do you know how much percentage rent they're really selling? And I'm telling you this because I've seen it happen. Okay, so they report one thing to the landlord and they report another thing to what there really is. And it's so easy nowadays because you don't need a big machine to sell. You can simply use this. So I think it creates a little bit of headache. Maybe that's why I'm seeing it less and less every day. And with a modified gross lease, that one, it just depends what the lease says. It could be that you're paying a basic rent, but then you're also paying a little bit of the maintenance, a little bit of this, and it just really does depend. So again, reading the lease is essential. Would the client be responsible for resetting the location back to what was originally leased upon the lease after getting it simple for use as your idea example? Okay, that's a great question. So it depends on what the lease says. Some leases will have a clause that says that you need to give it back to the landlord how you found it, how you rented it. So that's bad because now you're going to have to get demolition permits to basically put it exactly back how you rented it. And you won't know that until you read the lease and see if it has that. So yes, that might be the case. That might be the case that they have to put it back exactly how they found it. All right, so now I want to go into a letter of intent, which is a sample letter of intent. It's not one for you to use. It's just for you to have as an example. A letter of intent should be written depending on the commercial transaction, who the tenant is, what they want, who the landlord is, and what they want, okay? So a letter of intent for commercial lease is a document that outlines the basic terms and conditions of a proposed commercial lease agreement between a landlord and a tenant. It serves as a preliminary agreement that is used to initiate a discussion and negotiations between the two parties. The letter of intent typically includes the following information. So we would have basic information such as the name and contact information of the landlord and the tenant, the property address and intended use of the space. And I'm actually going to pull a sample letter of intent here. So we have like the names and contact information. So for any contract, the name of a company is the name of the company and the state where it was incorporated. Okay. So if you just have the name of the company, that's not a full name. It's the name of the company and the state where it was incorporated. Because I can have a company here in Florida that's called, Romy Inc., and I can have the same company in Delaware with the same exact name. So who is the one that entered into the lease? Is it Romy Inc. Florida or Romy Inc. Delaware? So you always want to have Romy Inc. a Florida corporation or Romy Inc. a Delaware corporation. Super important to put, and for any contract, to put who is what state is the company incorporated in, okay? You also want to put the name of the people that are going to sign on behalf of the tenant, right? And you want to do a little bit of due diligence in that you want to know whether these people are actually authorized to sign on behalf of the company. How would you check that? Well, you can ask for corporate documents. You could look at the Florida Secretary of State. You want to do a little bit more of due diligence. Even when you're putting it out for a listing, you want to know that people are signing can actually sign on behalf of the company. If you find something where the landlord is a company, the tenant is a company, but then the owner, right, has recently been deceased, then now you face an additional issue, which is that they don't have legal authority to enter into that lease until something has happened at the probate time, depending on the transaction. So that might open up an additional layer and something that you need to look into. So again, names seems basic, but it's very important. The name of the landlord too. You actually want to check the legal space, the legal description, the address, and see that the landlord name matches that of the person that's trying to rent to you or the company is trying to rent to you. Because there are big instances where people say, yeah, I have the right to rent you this premise, and in reality, they don't have the right to do it. And if it's a management company, then I would ask for some type of contract or letter from the landlord attesting that they have the ability to rent you the space. Recently, we just finished, but we had a situation where a client rented a location and they came to us to do the licenses and permits, right? So Romy, please, we need license permits for a location in this space. So I request the lease. I look at the property appraiser and I see that the lease, it's not signed by the owner of the property. So I'm like, okay. But the client's like, no, they told me at this place that they never had issues. So they submit everything like that to the city and the county. They're not going to have an issue. I said, okay, I've never done that before. We usually want to have the name matched, but okay, let's do it if you say so. We did it. And of course, the city and the county came back and say, this person or company does not have authority to rent this space because they don't own it. So please provide us with a lease. Please provide us with a sublease agreement. Please provide us with a letter of authority authorizing this. It took forever. Finally, we got it, but it took forever because had the client hired us in their leasing negotiations, we would have asked for that at the beginning. Hey, the name of the landlord doesn't match the name on your lease. We need to see something that says they have authority to rent you the space. And then they would have given it to us faster because they wanted to rent the space. But now, because the renting time had already happened, they took their sweet time. Meanwhile, my client is paying rent, right? And we're going to talk about that because your duty to pay rent is not tied to your ability to use the premises. Had he hired us, we would have negotiated that you don't start paying rent until you get the certificate of use. But anyway, we were not there. So the client at the end were able to fix it. It just took longer. He had to pay extra rent because this is not something that he did at the beginning before renting. So very important. Names, right? Name of the tenant, what state, make sure they have authority to sign on behalf of the tenant. Name of the landlord, make sure they actually own the property and they have ability to rent. And if they are a management company, then ask for a letter from the landlord or ask for something from the management company that have the ability to rent, because the city and county will ask you for that. It's going to delay your time to get your certificate of use in order to actually open up your business and start operating. All right. Now we have the description of the premises. This is where you put in the number of square feet you're actually renting, okay? And you will see that in the lease, the landlord is gonna say that this is deemed to be 1,000 square feet or 2,000, it is what it is. I tell my clients, go measure, make sure it's what you're renting. I don't want you to complain later that you're placing smaller than your neighbor and your neighbor's paying less rent at the same amount of square feet. So go measure it. And if they don't wanna do it, then they can hire somebody to do it. No, the realtor should not be the one measuring, because you want the client to be responsible and to have something to back into if things go bad. And things could go bad because they may realize later that they're paying for extra square footage than they shouldn't have, and that might be an issue. So you want to describe the premises, you want to describe the amount of square feet. The term, again, I usually recommend a shorter term, but with ability to renew. And if you have the options to renew, make sure you have a cap on the amount of rent increase. Because what good is it to have an option to renew if they're going to increase your rent by 20%? Then you're not going to want to stay there. Okay, somebody else is asking me, can the landlord require a platform to collect payment for sales to a tenant in a percentage rent? Yeah, they could require a platform if they agree to it, yes. Can the notes for the class be emailed to us? I will email you guys some notes, I think, and I will also email you guys the presentation. Let me see. Probably why the BOI was requested of business owners. Oh, news flash on the BOI. So FinCEN, the organization that regulates, all the fraudsters out there, basically made this requirement that every company for profit register who their beneficial owners were, who had the rights to sign on behalf of a company, and they open up this registry where you need to go and register. A bunch of litigation went back and front. 1 month you needed to do it, the other you didn't need to do it. Now the latest, I think it came out yesterday, is that if you're a US company, you don't need to do it. But if you're a foreign company, you need to do it, or a company with foreign owners. So you can be a US company with foreign owners and you still need to do it. I just saw it briefly. I have not fully looked into it, but just an FYI. I think that if you're a Florida entity or a US company with Florida owners, US people, you may not have to do the BOI anymore. But I will look into it and tell you guys for sure. But I think that's what's happening. All right, let's see. Then we have the term commencement date. The terms shall commence upon the later of or the date of substantial completion of the tenant improvements. And then you have the rent commencement date. The rent will commence on following the commencement date. So the term commencement date can be the time that you take possession of the place and you don't necessarily start paying rent. And the rent commencement date can be the date that you actually need to start paying rent. If you are a tenant, it doesn't hurt for you to negotiate months of free rent, even in an office setting. Hey, I'm getting, installed. I'm going to need 1 or 2 months of free rent, and then I'll start paying rent. Is that okay? Or you can tie down, especially if you're doing new construction or you're remodeling a lot, you want to tie down the time that you are taking the possession of the place. Sorry, the time that you start paying rent with the time that you get the certificate of occupancy, especially in restaurants, in places where you're doing remodelation. Like, to give you an idea, because I deal with this a lot, you might buy a restaurant, right? So you went and bought a restaurant and you're like, great, it's this fabulous pizzeria. But then you want to increase the number of seats, right? So now well, they're going to tell you, you need a bigger grease trap. All restaurants have grease traps. Now you need a bigger grease trap. And you're like, okay, I can just get a bigger grease trap, no problem. No, big problem, because the grease trap that's there, it's one that was grandfathered in for way back when. So now the grease trap that you're going to have to do to make bigger is going to have to comply to the new code, and it's going to cost you a lot more money. And meanwhile, right, you're paying rent. So that is why if you're buying places where you're going to do remodeling, you want to make sure that you negotiate that, or your tenant negotiates some time of free rent, or tie it together with the time that you can occupy the premises for that purpose. If you are any type of service provider, you can also negotiate for that. We had a client that had issues because she was a life coach, okay? But in that location, they didn't want anything with medicine related. It wasn't zoned for that. They didn't want that. But I said, this is a life coach. It's not, it's different. They're not seeing patients. They're kind of just giving you therapy for your life. And they still was a back and forth, and it was just a mess. So one advice that I give to tenants and realtors that are working with tenants, if you're either going to be changing the use of the place or modifying it or using it for something else, or it's brand new space, you can get something called a zoning verification letter, which is basically a letter that you request from the city outlining that type of service or products that you're going to be selling, that what is it that you're going to be doing, and you send it to the city, and they will respond to you in writing, and they'll say, yes, you're able to do that at that location, or no, you're not able to do that at that location. Okay, it's called a zoning verification letter. I'll give you another example. This one ended up in litigation, and I think it's still in litigation because it was a mess. So a client went and bought a school that taught music. Okay, she taught music for little kids. She thought it was great. I'm buying this school with instruments. She was teaching music. When she went and took over, she got this great idea that, you know what? Why don't I do a little, like not even kindergarten, like little daycare here. I'm already teaching the music after school. I have the teachers available during the day. They're trained. I can just do a little daycare to increase my income because the school teaching, music teaching doesn't give you as much money. And they said no. And the client came to me and said, but I told my realtor, this is what I eventually wanted to do. And I know it started as a school for little kids for music, but I wanted to have eventually a daycare with not a lot of kids, but some kids, because otherwise the business model doesn't work for me. And look, even my lease says I can do it. And yeah, her lease said that you're allowed to do a school of music, you're allowed to do a daycare, you're allowed to do all of those things. So she's like, Romy, who can I sue, the landlord or my realtor? And I said, well, your landlord can tell you can do whatever you want. But unless you tie your right, your duty to pay rent with your right to do those things at that location, it's really not your landlord's responsibility. You should have found out what you could do or not do at that location. And your realtor, well, they're not an attorney and they don't work for the city. So they may say you could do that, but they, I don't know how they guarantee that to you. And actually, she had it in text messages. Yes, don't worry. Yes, you can do it. Yes. So then the realtor got sued. But what I told her she should have done, which is the correct way to act, is simply get a zoning written to the city. There is a school of music right now. I plan to open a daycare. Is this something that's going to be allowed? And then the city would have said, no, you cannot do this because the zoning were not permitted. And then she wouldn't have rented that place. Now she ended up, I think, suing the realtor. The landlord sued her for non-payment of rent, right? Because you have to pay the rent, even if you cannot use it for whatever you wanted to use it, unless your lease says differently. But her lease didn't say that. So now she was evicted from the place for non-payment of rent. And she's still, because when they evict you for non-payment of rent, it's not just the rent that you didn't pay. All of the leases are going to have acceleration clauses to where if you have a lease of 3 years or 5 years, they're going to sue you for all of that amount. So she ended up with a judgment for all of those years. She was still fighting with the realtor here. It was just a mess, when all she needed to do was get a zoning verification letter to find out whether or not you could have that use at that location. That's it. And if you couldn't have, then she should have simply looked for another location. So advice to all of you realtors helping clients find premises. Find out if you're allowed to do it at that location, for those of you representing people buying businesses too, don't assume that just because a business is being operated there, they're going to be able to continue to operate that business. A great example of this are, for example, let me see, auto dealer shops, body shops, anything with mechanics. People think I can just go buy a mechanic shop. I can just go and buy a body shop and no problem. No, big problem. Because no city wants those shops anymore. So all of those shops are what's called grandfathered in. And in order for you to buy that business, you have to structure it in a way that it's not a sale of the company. I'm sorry, it's not a sale of the assets. It's basically a transfer of the company, and you have to sometimes do it in stages. Otherwise, the city will not give you the license to continue to be a body shop. And they actually had that situation. And in that case, they actually did sue the realtor too, because the realtor came, represented the buyer. They structured the transaction as a sale of the assets with the buyer's company. They went, bought the assets. It was it was a body shop. The realtor went, negotiated a new lease with the landlord under the name of the buyer. The closing went by. They went to the city to get the permits, and the city said, no way. But why? They had all the licenses. Yes, they did, but they were grandfathered in. You are not. You're a new company, and we're no longer giving permits for body shops. So in that case, they did sue the realtor, and they did sue the seller too, because they said that they were working in cahoots and that they knew that it shouldn't have been done this way. Craziness. So again, zoning verification letters, very important, especially when businesses are regulated. Also, even restaurants that have alcohol licenses, for example, in Wynwood, they will not give you any alcohol license unless it's by warrant, and it's a whole process. So it's very important to understand the regulations so that you're not sued and you're not being put in that position. All right, so early access is something that you can negotiate too. This is when you access the premise before you are taking possession or before you pay rent, simply to take a look at it. So maybe you can hire the people to do, the decorations for your windows. They can take measurements. They can look, your IT people can see where all of the locations need to go for the internet. In my case, I also got early access because I wanted to see where my cubicles could be and how they could be designed. So early access is simply that. You get access to the premises in order to just basically take a look, measure, not touching, not changing. It's just for you to get early access and be able to do all these things so that once you're ready to move in, you have it already scheduled and everything can just move along forward. Some questions. And they still can collect new rent from the new client when she paid the accelerated pay? Correct. In a residential tenancy, if you don't pay the rent, your lease is probably going to have an acceleration clause that says all of the rent is due. They're going to evict you. You're out. You still owe all of that judgment. And then they can go and rent to a new tenant. And it even gets better than that. The lease, it's going to say that they stay with everything there. So when they get a new tenant, let's say that it's a coffee shop, they're going to rent to a new tenant, and they're going to ask the new tenant for something that's called key money. Basically, give me money because you're getting all of this. It's a business and you can operate it. And that's it. Most commercial leases are going to say that the landlord has a lien, a UCC, over everything that's inside the landlord's premises. So yes, they can do that. They can accelerate the rent, collect on it, rent to a new person, and then give them everything you had in the location, and also ask the new person for key money because basically they're getting a business they can just operate. Somebody says, best defense is to have the attorney draw up and review the lease to be sure the factors are covered. Paying up front is a lot less money than going to court. I totally agree. Litigation is super expensive. Everybody gets drained with money, and the only ones that end up winning are the attorneys because it could be really expensive. So just invest in having your letter of intent review, invest in having your lease reviewed so that the clients understand what they're entering into. And because I have seen cases where the letter of intent, it was negotiated, wonderful things were there, but then the lease didn't include those things because nobody reviewed them. And then the lease is going to have something called an integration clause that's going to say, it doesn't matter what we said, it doesn't matter what we agreed, it doesn't matter. If it's not in the lease, then it's not going to regulate this transaction. And then you're facing litigation again. So some of the legal and regulatory compliance in commercial leasing, again, involves the Fair Housing Act, which prohibits discrimination in housing based on race, color, national origin, religion, sex, familial status, or disability. The Americans with Disabilities Act, right, which requires that commercial property be accessible to people with disabilities. We talked about the zoning and land use regulations. This is very important to know what you can do in that location. Building codes and safety requirements. If I'm negotiating a lease, I try to make the landlord make representations that the place is compliant with the ADA, is compliant with building codes, is compliant with safety requirement, is compliant with environmental regulations. If they don't want to agree to say those things, then I tell the tenant, hey, guess what? You really need to get an inspection. You can get an ADA inspection. You can get a building code inspection. You can get these inspections to be sure of what you're getting. Going back into the LOI, we had the use. When I'm representing the tenant, I like to write out the use of the premises to be very general, right? Because let's say that you are renting to open up a real estate brokerage. If you put real estate brokerage, then that's all you can do, a real estate brokerage. But if you put business services, real estate related services, and any other services related to real estate or business, now you can potentially include in there your mortgage company, your title company. You can do other things in there, okay? Let's go back to my example of the hair salon. So now everybody spends, well, not everybody, I don't know, but when I go to the hair salon, it's at least like 2-3 hours, right? You want to do your hair, your nails, all this stuff. And I'm bored. So what the hair salons do now is they have like jewelry to buy, clothing to buy, purses to buy. If the use on that lease says hair salon or cosmetology salon, then they're already violating the space or violating the lease because now they're using it for retail services. So if I were representing the tenant, I would have made that, beauty salon, beauty related services, and beauty and retail related services. I give myself a broader description so that if my client eventually wants to start selling, makeup, jewelry, they're not violating their lease. Okay, so it's always good to think broad when we're dealing with representing the tenant. When we're representing the landlord, no, we want to narrow that use. What is it they're going to be doing? And only that. So that way, if they start doing something else, we can ask for more money, right? Because I'm representing a landlord, I'm thinking about money. So it depends on who you're representing. Also, we want to include, of course, the rent amount. We want to say that there is going to be an increase, but that the increase, like on the renewals, it's not going to be more than maybe 3%. It just depends what's negotiable. You also want to include what the operating expenses are going to be, because landlords can include everything under the operating expenses and charge you for that as additional rent. And you want to include audit rights to the tenant. You want the tenant to be able to audit what is it that the landlord's charging. Because if they're not able to audit, then the landlord can charge for whatever they want, for their trips to Europe, to Peru, to anywhere in order to promote the location, their marketing expenses, the salaries to all their family members where they're really not doing anything, but they get paid anyway. All those things can be considered additional rent and operating expenses that you're going to have to pay unless the clause in the lease says that or not, and you have some type of audit rights to keep the landlord accountable. We're going to specify the security deposit. We're going to talk about tenant improvements. Is the landlord going to give us some money to improve the place? Are they going to improve the place? All of that should be part of the LOI. We're going to talk about assignment and subleasing. Maybe you already know that your client is going to be subleasing to maybe the people that rent the chairs or to other companies, and that's a deal. Then that should be part of the LOI. I like to negotiate an early termination. I'm sure you guys are familiar with this from the residential leases, where you have an early termination of basically you pay 2 months and then that's it, you can leave the place. You're not going to see that by default in commercial leases, but it's something that you can negotiate. You can say, you know what, I'm going to pay 2 months, 3 months, 7 months of rent. Yeah, hear that, 7 months of rent, but let me out and I don't pay you anymore. And then if the landlord agrees, good, then you're good to go. I had a client who had a 10-year lease, okay? And the reason why he entered into a 10-year lease is because he bought a gym franchise that forced him to enter into a 10-year lease. In order for him to buy the franchise, you needed to be in a 10-year lease. Then the gym franchise didn't work. They were in federal, a lot of litigation against the gym franchise because basically the gym franchise defrauded all the people that bought from them. But here's my client with a 10-year lease. And I think his rent a month was, I don't know, $10,000, something like that. And my client was good, meaning he had money, right? He had money, obviously. So I told him how it was. I'm like, look, you have a 10-year lease. You are the personal guarantor. Your monthly rent is $10,000. If they sue you for non-payment of rent, they're going to be able to accelerate and you're going to be responsible for that 10-year lease amount. Okay? And I mean, if you don't have money, then they're not going to be able to collect. And my client's like, no, Romy, I have money. Okay, so they're going to be able to collect, right? So what are your options are, let's negotiate. Of course, he didn't have an early termination clause. So I said, let's start by offering 4 months. Let's see what they say. We start with 4 months, 5 months, 6 months, 7 months. Thank God they agree on 7 months at $10,000 at $70K. But that was a lot less than 10 years at $10,000 a month when my client knew they would be able to collect. Plus, I told them litigation is horrible. You already are in litigation on this side, but here you're the one that's going to get sued, and it's just going to create more of a headache. But it's up to you. At that time, we were able to negotiate for 7 months, which I think was a win-win. Had I wished that the client would have been advised, I was not involved at the renting part. Like, yes, okay, you need a 10-year lease, but negotiate an early termination if it doesn't work out. he would have been in a better position maybe, but of course they didn't negotiate that. So whenever possible, you can negotiate for an early termination, which can be a set amount, a couple of months, and if the landlord agrees, good for everybody. Condition of delivery, if you're the tenant, you want to negotiate that the landlord represents that all building systems are in good working order, that there are no structural or major repairs in the building, and that the premises are in compliance in all laws, including without limitation to the Americans with Disabilities Act. If you have something like this in the lease, something like that, then you're in good position because now the landlord's saying that it is in good conditions, that they're not violating those laws. And if you get sued for that, then now you can sue the landlord and the landlord will indemnify you for all those expenses. But if you don't have that, it doesn't happen. If we already know what type of signage the tenant's gonna have, then we talked about it here at the LOI level, because maybe the tenant has one company name, but they're going to be operating under a DBA or fictitious name. So we want to put that here in the LOI. Parking is super important. Even if you see the whole lot, give me 1 second. Even if you see that the whole lot is empty, eventually what I see happening is the landlords rent out those spaces, rent out like the whole lot to another company, and then that company ends up renting the space back to their tenants. So while you get into the lease, they tell you, oh no, there's all this space, don't worry about it. You're not paying for any rent for parking. But then eventually when they give that lot to another private company to rent, you're going to be charged for rent, or you're not going to have any spaces for your clients or for your what's it called, for your employees. So what I like to negotiate is, even if it's an open space, I want to negotiate that they have the right, whenever it becomes that the parking becomes rented out or that you need to pay for it, that they have the right to 6, 7, or 10 parking spaces for themselves and for their customers. That's something you can negotiate at the LOI level. If they're telling you that's never going to happen, then they shouldn't have an issue with you putting that clause there if they're never going to restrict parking. So that's something to consider. I see it a lot happening, especially in newer constructions. So please have that in your mind. Access, usually depending on the place, you will have access 24 hours, sometimes some place limited. So it's important to understand what your access is. Brokers, that is where you would put your brokers, your commission, what is it that you're negotiating, that you can get commission upon any renewal term, that you can get commission upon any type of purchase if the same tenant buys a location. Sometimes landlord would like to include there they have the right to relocate you, meaning they can move you from here to here. If that's the case, then the lease should say that they would pay for all of your relocating expenses, for all of your marketing expenses, because now you have to market into a new location. Unless you don't want to agree to the relocation, then the lease shouldn't say they have the right to relocate you. Sometimes the lease are going to have some radius restriction, which means that you are not allowed to open up the same business within that area. For example, if you're renting an ice cream place and you're paying percentage rent, right? Then the landlord doesn't want you to open the same ice cream place, 5 miles away, because the customers from that place might go to the other place and take away from this business and then less percentage rent. That might be there. You're going to have some type of operating covenant that's going to say you have to operate. Exclusive rights, you can negotiate for this. If you don't want the landlord to rent to a competing business, then you can negotiate for that exclusivity and say, I don't want you to rent, let's say that you're a hair salon. I don't want you to rent to another hair salon in your shopping center. Or if you're a real estate brokerage, I don't want you to rent to a real estate brokerage in a shopping center. You can negotiate for that in there. The hours of operation would also be included, so you know when you need to operate or your minimum hours. If you have the right to use outdoor seating, then you want to include that in the LOI, because it might not be part of your percent of your square footage rent. You just simply have the right to use it depending on the zoning during the day, and then take out the chairs at night. That we're going to have to see depending on the zoning regulations in that particular place. And lastly, this LOI, it could be, I call it an agreement to agree. You can agree that it's non-binding, so it's just simply an agreement to eventually agree. You could say that certain parts are binding, right? Or you can say that all of it is binding. That just depends on the particular transaction. About location is key, understanding the market, knowing the client's needs, it's super important. Negotiating lease terms at the beginning, from the time that you're doing the LOI. Work with experienced attorneys. I know that all of attorneys seem to be the same, but they're not. Like, I would never do criminal law, personal injury, family law, like never. I don't know anything about it. I don't want to learn. So don't use attorneys that are not familiar with commercial leasing to do a commercial lease. It's not just a simple agreement. There's a lot of ramifications. A lot of times that ends in litigation. And the commercial agreement, it's really going to regulate your client, your tenant, and what they can or cannot do in that location. And you want somebody that's staying up to date on the legal requirements. So a little bit of us and a little bit of what we can do. That's me, that's my team. Even though we're here in Miami, we do help all over the state of Florida. Commercial leases is Florida law, so we're able to assist all over. We speak both languages, of course. So we're able to analyze a lease that's fully in English, draft an email in Spanish so the client understands what they're getting themselves into, and negotiate with the client, and then help them with everything else, like obtaining licenses, permits, dealing with violations, forming the companies, negotiating any type of commercial contract that the client might need, and then of course dealing with the litigation and helping the client be in the best foot forward. We also do immigration, real estate, law, estate planning, probate, and anything that has to do with businesses. It's something that we can do. That's our social media, that's our WhatsApp and our website. And I think that's it for now. I should have everybody's contact information, but if not, I will ask my team. Let's see, people are asking me some questions. How much is an average cost to write up an LOI? Anything that has to do with money-wise, email me, because now you guys have the NAR settlement and we're not able to discuss anything that has to do with money. Where might we find landlords and tenants for potential business opportunity? Since usually the landlords come to me and the tenants come to me, and usually the realtors are the ones coming to me, I don't really know where to find them, but I would suggest reaching out to your real estate association, because they do have a lot of networking activities that you may want to participate. Thank you so much.